reconvening on the motions calendar. David Mann versus Amy Markle. Appearances, please.
Good morning, Your Honor. David Mann, on behalf of myself.
Good morning.
Good morning, Your Honor. Alex Ghibaudo, 10592 on behalf of Amy Markle, and she's also present.
All right. Defendant's special motion to dismiss pursuant to the matter of statute 41.660. Go ahead.
Thank you, Your Honor. I think before we begin, we gotta reference Mr. Mann's complaint, see what exactly what it is that he's talking about. In his complaint, he states that defamatory statements were made on Facebook or Instagram, which were made publicly. In his opposition, he makes a litany of or references a litany of statements that were not referenced in his complaint. What I want to distinguish is between those statements made public on Facebook and the remainder, which are all the ones that he lists on his in his opposition. We filed a reply Friday. I hope the court had a chance to take a look at it, because we run through those three categories of statements: those that are public, those that are not subject to, and those that are not subject to defamation claims. The public statements are the ones that Amy states in her declaration on paragraphs 18 and 19. Those are the only statements that fit what Mr. Mann alleges were public claims made on Facebook. That's it. And those two statements don't even name him. His name is not referenced in those statements. They're generally opinions that Amy has about what you should do when hiring a lawyer. Mr. Mann jumps the gun and assumes that she's talking about him and files a complaint against her. The remainder of the statements were actually statements made to his paralegal, Michelle Beauregard, who's present here. You can see it says paralegal Michelle Beauregard. Those statements are actually not public. Those are considered private statements. Those are considered essentially statements made to Mr. Mann because she is an agent acting on his behalf. And we provided exhibits to that effect in our reply brief, Your Honor. And I hope you had a chance to look at that because they match exactly the litany of statements that Mr. Mann alleges were made against him and were defamatory. The remainder of the statements that he claims were defamatory were statements that Amy made in her declaration in support of this motion to dismiss. As this court knows, she's absolutely immune from any claims for those under the litigation privilege or yeah, she's just immune from any claims that arise from those statements because they're made in support of her motion. In addition, I think I know that the anti-SLAPP statute states that anything that happens here is not evidence that could form the basis for any liability going forward. So all we're left with are the two statements that Amy makes in her declaration, paragraphs 18 and 19. Those do not name Mr. Mann at all. Let's remember that. So now we turn to the anti-SLAPP statute. So what we need to show there, what Amy needs to show, is that those statements were a good faith communication made in furtherance of her rights of free speech in a public forum, and that were a matter of public concern that were either truthful or made without knowledge of their falsity. So I'll run through those real quick. Good faith communication, she never mentioned him in those public statements. So there's no way you could show the opposite of bad faith by just looking at the fact that she never mentioned his name. So she had no intent to harm him, no intent, no ill will. All she did was say we had a bad experience with a lawyer without naming that lawyer, and then goes on to give her opinion about what people should do when hiring a lawyer. That's a good faith communication, Your Honor. Obviously, the statements were made in furtherance of her rights of free speech. That's not really. There's not much to argue there. They just were. They were in direct connection with an issue of public concern. Here's where Mr. Mann, in his opposition, he disputes that. He says he's a private figure and nothing that he does really matters to the public. But in the Abrams v. Sanson case that we cite in both our motion to dismiss and in the reply, the Supreme Court specifically states an attorney's behavior, especially towards judges in judicial proceedings, implicates the operations of the court and is a matter of utmost public concern. It's clear there what an attorney's behavior generally, but especially what happens in court, matters to the public. And so it's a matter of public concern. So that's satisfied. Without belaboring the point, we then in the brief and the motion to dismiss go through the Shapiro factors that also demonstrate, even under those factors, without even considering Abrams v. Stanton, which is the recent case, that those statements are a matter of public concern, Your Honor. Yeah, they were undoubtedly made in public, in a public forum, Facebook, where she has several thousand members. And their pure opinion actually they just can't be rendered either true or false because they're opinions. And it's an opinion Amy rendered concerning what her members should do when considering a lawyer without naming Mr. Mann at all. The test there is contained in the Pegasus case, whether it's an opinion or not. Whether a reasonable person would be likely to understand the remark as an expression of the source's opinion or a statement of existing fact. Amy doesn't make any claims as to any existing fact concerning Mann. All she says, this is my opinion on what to do when you hire an attorney. So that's it. That's the anti-SLAPP statute. She satisfies all the elements of it. And so the next step then is to look and see if Mr. Mann has any probability of success on the merits. Again, so we'll look at the first two factors here with respect to defamation. A statement of fact made by defendant about plaintiff. He was never named, so he fails on the first prong right away. On the two statements that were actually publicly made. The defamation elements of defamation also require publication to a third party that's not privileged. The statements to his paralegal, again, in our reply brief, we cite a number of cases that stand for the proposition that that statements made to an attorney's agent or a person's agent are essentially statements made to that person. So he fails on that prong as well. And then we look at the third category of statements of those that are contained in the declaration made by Amy. And those are privileged communications, and she's absolutely immune from any liability for him under the litigation privilege. So he has no probability of success on the merits in his defamation case, Your Honor. With respect to his intentional interference case, it's really predicated on whether or not he was defamed. And so without defamation, there's no interference with any contractual relationship he has with a third party. Nor does he name anybody that he had an issue with because of these statements. One of the elements of that is the absence of privilege or justification by the defendant. Here again, she's privileged. She has it was a good faith communication made in furtherance of her rights to free speech. The statements made to Michelle Beauregard, who's present here today, were not statements made to a third party. They were statements made to an agent of Mr. Mann's. And the remainder of the statements that were contained in the declaration, she's absolutely immune from any liability for those. So with that, Your Honor, I would argue that the motion to dismiss should be granted and attorney's fees and sanctions awarded to my client.
All right, thank you, Mr. Mann.
Yes, Your Honor. I'll be brief, and I just had dental surgery, so I'll try to speak clearly. He just admitted that there are genuine issues of material facts. And of course, an anti-SLAPP motion is like a motion for summary judgment because we absolutely say that all of those were published. I make my offer of proof. We have 6 witnesses. I brought a witness here today. We're going to subpoena Facebook, and Facebook's already been contacted. And I saw them with my own eyes sitting in a Starbucks parking with Michelle. So I just have 5 really quick points. Secondly, no communication falls under anti-SLAPP unless it's truthful. I went ahead and skipped to the proof phase of this litigation, and I put in a public record a list of all my clients. I'm in good standing with every single one, or there's a notice of withdrawal where I completed my service. I was never fired, and the proof is there for anybody that's listening to us right now. Go look. And a lawyer is supposed to do reasonable research, and opposing counsel should have took a quick glance at Odyssey. Also, in her own words, she proves the statement about me stealing cash is false, as she then put in her declaration it was a check because she can't keep her lies straight. Also, even if we go with everything that opposing counsel just said and none of the other stuff was really published, what she admitted to in her declaration, our phone rang off the hook right after she put that because I was the designated attorney in that group, and everybody's like, Amy's out there talking about you. Point 3, in such a motion, A court must rely on credible evidence, and that's why opposing counsel's motion keeps failing on this. Same thing happened last time. There's no evidence presented, Your Honor. Just lawyer arguments. There's not a word in there that it was about the public interest, not a word in the declaration that I was fired. Completely silent. Point 4 of my 5. Amy's motion for summary judgment, they must prove there's no genuine issue of material fact. Well, we could list 20 right off the top of our heads. Was I fired or wasn't? Was it cash or a check? Was it stolen or given? Did the underlying opposing counsel says she got kicked out because of my promotion? It actually moved months earlier, which anybody could hear if they would just read it. So I have several witnesses. I brought one today, Facebook. We could prove that. So my point, my argument at this point would be the statements were absolute lies. I proved it for that. And if they disagree that there's an issue of material fact, so there should be no dismissal. Finally, this is probably the most interesting part on the tortious interference. The opposing counsel says we just put on the end of the defamation. Has nothing to do with the defamation. Several people are suing her over this scam website. How do I know? I'm their lawyer. As soon as I get the waiver signed, we'll be filing. We've contacted Facebook. Her MO is to get people in there. She promises things. She demands things. When the relationship sours, she defames them. So she called my clients. It's not because she necessarily put something out there, but she called them and spread lies intentionally. And also, I just found this out last night. I haven't had time to take any legal action, but I will, guaranteed. Someone called me and said, a person, well, I better not say her name right now. She falsely claimed that I was her lawyer and threatened this person that I was going to sue this person when Amy has never been my client. Ms. Markle, apologize. Ms. Markle's never been my client, and I wasn't about to sue anybody. So in conclusion, Your Honor, briefly, we provided proof that the statements were lies. We have proof that they were published. If they disagree, then they're material facts at issue. And in any case, there's no evidence presented, and it's her burden. This case should be continued. And my last thought, Your Honor, is I wrote a kind and nice settlement letter on a couple of days ago, and opposing counsel, I said, please let's not go to court. Please let's not have appeals. I don't want any money. I'm retiring. This is my last case. All I want is for her to post, because he wants to do a settlement in public, apparently. All I want is a post that I was never fired. I'll put it out there right now. Post that I was never fired, and we could put it on the record and settle today. I don't want my retirement to be full of litigation, but I'm not going to stop until the record is corrected. Thank you, Your Honor.
All right. Thank you. Response, Mr. Ghibaudo?
Yeah, Your Honor, the reason why I'll start with the settlement offer. The reason why I added that is because it demonstrates that this is the epitome of an anti-SLAPP statute. It's an anti-SLAPP statute, or a SLAPP suit is a strategic lawsuit against public participation. What Mr. Mann seeks to do is either force Amy to say he's a great attorney, or if she does not do that, he's going to drag her through 3 to 4 years of litigation, hundreds of thousands of dollars, and immediately appeal this whatever determination, or if this court makes an adverse determination for him. That's the epitome of a SLAPP suit. The process is the punishment. That's what Mr. Mann's trying to do, and I submitted that. I referenced the rule under which I submitted it. It's made for other purposes other than the offer of settlement under the rules of evidence. So it was appropriate to do that, and that's Bates Stamp 16 in our reply to our opposition. The exhibits in support of that. The other thing is that this is not a summary judgment motion. The standard isn't summary judgment. The standard's contained in 41.660. He's got to demonstrate that he has a probability of success on the merits if this court is convinced that the anti-SLAPP statute applies. Again, he provides no evidence, actually. He provides little snippets of things. He tries to embarrass my client, even in his opposition, where he says that she started an OnlyFans account, which isn't even relevant to this. And when you click the OnlyFans account link, it's a picture of Jesus that says, I'm essentially that I'm disappointed in you. It's a joke. It's a joke meme. And here he is posting that in the opposition, knowing that that's what it is in order to embarrass her. Again, SLAPP suit is the epitome of a SLAPP suit. He doesn't even know the standard for summary judgment. In it, he states that the standard is de novo. That's an appellate standard, Your Honor, and it's not the standard that this court should use in determining this case. As far as the evidence, the person that provides no evidence is Mr. Mann. His declaration is essentially a recitation of his opposition, almost identically. He admits it. We provided a statement, a declaration by Amy, which is evidence, it's testimony, and we provided all of the text messages between Amy and Mr. Mann's paralegal to show that everything that he said, the litany of statements he claims are defamatory in his opposition, are all either contained or all either privileged communications or they're private communications made between Mr. Mann and his client, or the agent of his client and Amy. And the only statements that are actually public are those ones that Amy stated in her declaration in paragraphs 18 and 19. Mr. Mann doesn't deny that at all. It's all puffery. I've got all these people, and let me go forward. I'll prove all this stuff. And now's the time to prove it. If he had any affidavits from these people, he could have submitted them. If he has other posts that he says are defamatory, he could have attached them. He's done nothing. You know, again, his declaration is a complete recitation of his opposition. And those snippets of things that he actually adds are taken out of context and are contained in actuality in the discussions between his agent and Amy. So that's all I have, Your Honor.
What do you understand to be the situation regarding the group? I want to make sure I understand that.
Your Honor, may I didn't mean to interrupt.
I just posed a question to defense counsel, Mr.
Oh, thank you.
Yeah, the Facebook group is just proof that it's a public posting, but the only public postings made in that Facebook group are the ones that do not identify Mr. Mann. So that satisfies the anti-SLAPP statute. Those are the only statements that were made publicly. Mr. Mann's not going to dispute that. It's just, if he does, it's just not true.
We have disputed it, Your Honor, and we do, and I brought a witness today, and I've explained how. And just one
hearing today. This is a motion. This is a motion to dismiss. This is not a trial. Okay. Not an evidentiary hearing. I'm looking at the papers that have been filed and at the arguments that are being made based thereon. Okay. So.
Yes, Your Honor. May I?
You want to say anything else?
I didn't mean to interrupt. There was a delay on my phone. Yes, Your Honor. My last comment is just we vehemently deny that they were not public. They were all public, and I've explained how we will prove that. And I brought two witnesses today, myself and Michelle.
What's interesting to me is when I look at your complaint, I don't really see any statements alluded to. I mean, I see I see some reference to concepts of statements that were made, but I don't see any actual quotations of statements.
Here's why, Your Honor. It's a notice state. I looked it up. It's not like fraud where we have to plead it with specificity. No lie is protected, and I focused on proving that they were lies. There's actually more, too. So it would be impossible to list them all right now, but I've listed several.
Okay. All right. Thank you. The matter stands submitted. I need to review it further. I'll issue my ruling as soon as I can. Okay? Thank you.
Thank you, Your Honor.